personnel, and members of the civil service. We give special thanks today to our teachers during this first week of the new academic year. May all that is done this day be for your greater honor and glory through Jesus Christ, we pray. So may our Lord Jesus Christ be near us to defend us, within us to refresh us, around us to preserve us, before us to guide us, above us to bless us, who lives and reigns with the Father and the Holy Spirit, one God, forever and ever. Amen. To the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, power, and glory, forever and ever. Amen.
House is now in session. Minutes of the meeting held on Tuesday, the 28th of August, 2018.
Mr. Deputy Speaker, I beg to move that the minutes of the proceedings of the Honourable House of Assembly at its meeting of Tuesday, the 28th of August, 2018, which have been circulated, be taken as read.
I'd like to second that, sir.
The question is that those minutes become, if there's no errors or omission, please those minutes be confirmed.
Mr. Deputy Speaker, I beg that those minutes be confirmed.
All those in favor say aye.
Second that, sir.
All those in favor say aye.
Aye.
Those against say no. The ayes have it.
Petitions, papers.
Mr. Deputy Speaker, I am commanded to lay the Barbados Fire Service Annual Report 2016 in the name of the Honourable Minister of Home Affairs.
Mr. Deputy Speaker, I am commanded to lay the Barbados Pork Inc. Annual Report for the year ended March 31, 2017.
Government notices. Private members' notices. Notices of questions. Reports from Select Committee.
Mr. Deputy Speaker, I beg to move that standing orders numbers 6, 16, 18, 20, 42, 5, 43, and 44 be suspended for the remainder of the day's sitting.
I'd like to second that, sir.
The question is that those standing orders so mentioned be suspended for the remainder of the day's sitting. Those honourable members in favour, please say aye. Those against say no. Methinks the ayes have it. Government business is now the order of the day.
Speaker, order number 8. In the name of the Honourable Minister of Finance, have been introduced by the Honourable Minister sworn in the Ministry of Finance. We move the second reading of the Appropriation Amendment Bill 2018.
Honourable Member for Christchurch East Central.
Good morning, Mr. Deputy Speaker. In moving the second reading of the Appropriation Bill, the amendments to the Appropriation Bill 2018, this reflects the change in respect of the structure of government to include the finances for the newly created ministries such as the Ministry of Maritime Affairs and Blue Economy, the Ministry of Information, Broadcasting and Public Affairs, the Ministry of Youth and Community Empowerment, the Ministry of Labour and Social Partnership Relations, the Ministry of Transport, Works and Maintenance, the Ministry of Environment and National Beautification. Mr. Deputy Speaker, the appropriation bill was passed earlier in February this year, and so this morning the Ministry of Finance is just presenting the bill as it currently reflects the structure of government, and so therefore after the passing of this amendment this morning, the government and the accounting officer should be in a position to discharge of their duties in the manner in which the government has been constructed. And so this amendment this morning, Mr. Deputy Speaker, is simply a procedural measure on the part of the government, but I want to assure the House that the Ministry of Finance, as we have entered into an arrangement with the International Monetary Fund, is in a position to make sure that we're able to maintain the targets, monitor within the respective ministries, such that we're able to execute the program of government over the course of the adjustment period. So, Mr. Deputy Speaker, this is a simple procedural matter this morning, and I therefore beg to move that the bill be read a second time.
The question is that this bill be read a second time. Those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Deputy Speaker, I beg that you do not leave the chair and the House resolve itself into committee for further consideration of the bill.
The question is that this bill, that I do leave the chair, this House goes into committee on this bill. All those in favour, please say aye. Those against, please say no. The ayes have it.
This House is now in committee.
Madam Chair, I beg to move that Clause 1 stand part.
Question is that Clause 1 stand part. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
Clause 2.
Madam Chair, I beg to move that Clause 2 stand part.
Question is that Clause 2 stand part. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
Schedule.
Madam Chair, I beg to move that the amended schedule be descheduled to the bill.
Question is that the schedule be the schedule to the bill. All honourable members in favour, please say aye.
Aye.
All honourable members against, please say no. Methinks the ayes have it.
Madam Chair, I beg to move that you do not report to His Honour the Deputy Speaker the passing of one bill in the committee with amendments.
Question is, I now report to the Deputy Speaker the passing of one bill in committee. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
The chairman of committee has reported to me the passing of one bill in committee.
I'd like to move that this bill be read a third time.
Second. Second.
I beg to second that, sir.
Question is that this bill be read a third time. All those honorable members in favor say aye. Those against say no. Methinks the ayes have it.
Mr. Deputy Speaker, I beg that this bill be now passed and be cited as the amendments to the Appropriation Bill 2018.
Seconded.
Beg to second that, sir.
Question is that this bill be now passed and be so cited. All honorable members in favor please say aye. Those members against say no. Methinks the ayes have it. This bill is now passed and so cited.
Order number 5, sir. Order number 5. Order number 5.
Yes, ma'am.
In the name of the Honorable Attorney General, this bill has been assigned to the Honorable Minister of Energy and Water Resources.
Honorable member for Christchurch East.
Mr. Deputy Speaker, I rise to pilot and spearhead the debate on the amendments to the Offences Against the Persons Act 2018. Mr. Speaker, because we are seeking to abolish the mandatory death penalty, it is not necessary to consider simply the Offences Against the Persons Act and the amendments thereto, but there are other pieces of legislation that will necessarily impact and will have to be amended in order to have the mandatory death penalty under our laws removed, and any amendments make sense. The other acts that are necessary of amendment to achieve this are the Constitution of Barbados, the Penal System Reform Act, and the Criminal Procedure Act. So I propose, with your leave, to treat this as a cognate debate. So while I am substantively debating and presenting the amendments to the Offences Against the Persons Act, my presentation will touch and concern all of the other acts mentioned, so that when we come to deal with those, a debate will not be necessary. It is impossible for me to do otherwise, so I seek your leave to treat this as a cognate debate. I am grateful.
Proceed.
Mr. Deputy Speaker, there are few things in Barbados that evoke... Sorry, Mr. Speaker, I beg to move that this be treated as a cognate debate.
All those honourable members in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, there are very few things in Barbados that capture the attention of the public in Barbados and has generated as heated a debate nationally, in shops, in churches, among gatherings of friends, as the death penalty in Barbados. Now, the debate for the most part has centered as to whether or not there should be a death penalty in Barbados. But that is not what we are debating here today. And there seems to be some misunderstanding as to the nature, the exact nature of our debate. Mr. Speaker, we are here to debate amendments to the Offences Against the Persons Act and other legislation, supporting legislation, to remove the mandatory nature of the death penalty in Barbados. That has to be made clear from the very outset, the mandatory nature of the death penalty in Barbados. It is perhaps useful, Mr. Speaker, before I go into the details and particulars of the amendments, to frame this in a way that makes sense. I'm going to take my time with this, Mr. Speaker, because it is not, I'm here today not simply to convince my colleagues and to convince the Leader of the Opposition that we should pass the amendment. But it is also necessary that at the end of this debate, the general public in Barbados and anybody listening understands fully how we got here, what it is we're trying to do, the implication. But the man got up and he said, based on all that he has heard, and he has been following the boy's progress, based on what he knows as a fact, if the court wishes to sentence him to imprisonment, let it not be in respect of his case. He is asking the court that imprisonment not be considered for his case, the one where he was shot. And the court eventually put the boy on probation. He did not serve a day. That boy, and I'm deliberately not calling name and not being too specific, that boy is now one of the managers in a very prominent business in Barbados with a number of people under him, and he has continued up to now to help at-risk youth. The point of that, Mr. Speaker, Mr. Deputy Speaker, is that had the judge not had the discretion to weigh all of the circumstances of that case, then that boy would have been lost away in jail. 14 robberies and 1 shooting, he would have been lost away in jail. So the Inter-American Court and the CCJ and all the other human rights courts make the point that from the time the judge has no other option but to sentence somebody to death, you have stripped away one of the fundamental pillars of our criminal justice system, which is judicial discretion. You've denied the judge the opportunity to take all of the circumstances into consideration and to give the sentence that fits the crime and also the circumstances of the offense. Mr. Deputy Speaker, our system also depends on something called the separation of powers. A lot of people don't actually understand what that is. The separation of powers separates the various arms of government from undue influence into the workings of the other arms of government. The legislature, the executive, and the judiciary. So, the legislature should not actually be giving instructions to the executive as to how to carry out their function. That is why MPs and cabinet ministers are not supposed to get involved with who gets hired or who gets fired in a ministry. But equally, the legislature is not supposed to interfere into the realm of the judiciary. Now, the argument has been made over and over and upheld that if you legislate that if X is the crime, then Y must be the sentence, then that is the legislature interfering into the judicial realm. You can give a discretion, you can give a range, say that a sentence should be between 0 years and 100 years, or 0 years and death. Or you often hear in the drug cases that you can be fined up to $500,000 and or X time in prison, up to X time in prison. They give alternatives. So most of the cases that have heard death penalty cases from Barbados or appeals from Barbados have insisted that the mandatory sentence fetters the right of the judge, the discretion of the judge, and is also a case of legislative interference into the judicial system. So, what I want to hammer home again, I have my own views, but I represent the Cabinet of Barbados, and I represent my constituency. And let there be no doubt that the Cabinet of Barbados has not made a decision to abolish the death penalty. Nothing we're doing here abolishes the death penalty. What we are doing simply is abolishing the mandatory nature of the death penalty and making corrections and amendments to legislation to give effect to that. Now, if we go a little bit further, Mr. Deputy Speaker, it is not as if we had a choice. While we might have delayed in following the dictates of the Inter-American Human Rights Court or following the dictates of conventions that we are signatories to, from the time the CCJ made the ruling that the mandatory death penalty was unconstitutional, the CCJ set out what the new law for Barbados was going forward. So the law was already decided with the decision of the CCJ in the Nerve case. All we are doing now is making the legislative amendment that reflects the decision of the CCJ and making our laws harmonize. So having given that broad overview to try to explain how we got where we got, I am now going to deal specifically with the amendments in the respective pieces of legislation. I start with the Offences Against the Persons Act. The bill we are purporting to debate today would make provision for the repeal of the mandatory imposition of the death penalty for the offence of murder under Section 2 of the Offences Against the Persons Act and for other matters related thereto. So, Mr. Deputy Speaker, Clause 2 of the bill deletes Section 2 of the Offences Against the Persons Act and substitutes a new section. The proposed new Section 2 provides as follows. Section 2 of the bill seeks to abolish the mandatory imposition of the death penalty by expanding the sentencing options available to the court for the offence of murder, pursuant to the decision in the case of Nerve and the Queen. Once again, we restate that the Cabinet has made it clear that the death penalty should be retained as a punishment for the offence of murder. Accordingly, Section 2.1 of the bill, 2.1a of the bill, makes provision for the retention of the death penalty as a punishment for the offence of murder. However, Section 2.1b provides that a person convicted on indictment for murder may also be liable to a sentence of imprisonment for life. The language employed in terms of making the person convicted liable to imprisonment for life should be interpreted in accordance with Section 22(5) of the Interpretation Act, Cap 1. This means that the sentence of life imprisonment is to be interpreted as the maximum sentence of imprisonment that can be imposed by a court on a person convicted of the offence of murder. In other words, where the court deems not that the appropriate sentence is not hanging, but actually imprisonment, then it would indicate the legislation sets out that the person is liable to a sentence for life, but that does not mean they will get life. The court then has the discretion to give them between 0 years up to life imprisonment. So this allows the court to tailor the punishment to fit the crime and to take into account the particular characteristics of the crime and the participation and degree of culpability of the defendant. Section 2, Part 2 sets out the circumstances in which the court may impose the death penalty on a person convicted for the offence of murder. So if we go to Section 2.2, a court may sentence, this is brand new, this is what the court has to factor into when making the sentence of death. A court may sentence a person convicted of murder to death where A, the murder was committed with a high level of brutality, cruelty, depravity, or callousness. B, the murder involved calculated or lengthy planning. C, the deceased was a judge, a magistrate, the director of public prosecutions, or a legal officer in the Department of Public Prosecutions, and the office of the deceased was a factor in the commission of the offense. D, the deceased was a member of the Royal Barbados Police Force, the Defense Force, a member of the Special Constabulary, or prison officer, and the office of the deceased was a factor in the commission of the offense. The deceased was a member of a group of persons who have a common characteristic such as race, nationality, ethnicity, or religion, and this was a factor in the commission of the offense. F, the deceased was a witness or a juror in a pending or concluded trial, and this was a factor in the commission of the offense. G, the deceased was particularly vulnerable because of his age, health, or disability, or because of any other factor. H, the person convicted was convicted of 2 or more offenses of murder, whether or not arising from the same circumstances. Or I, in the opinion of the court, there are any other exceptional circumstances which must be taken into account and which justify the imposition of death. If you look at the criteria for the imposition of the death sentence, the large part of it, the bulk of it, involves some measure of premeditation. That it was not a random offense, that the person who was killed was targeted by virtue of there being a judge, a magistrate, a police officer, a prison officer, of a certain racial orientation, etc. So in this case, it imputes a level of thought, premeditation, and execution on the part of the person who committed the offense. This is brand new, and this is what the judge has to sit down and run through all of this. Look at all of them, look at the criteria, weigh up the criteria, and decide based on all of the stated criteria whether or not death is the appropriate sentence. Section 2.3 takes into consideration decision in Pratt and Morgan. Thus, Section 2.3 requires that where the court sentences a person to death, that sentence must be executed within a 5-year period, or the risk being in breach of Section 15 of the Constitution, which seeks to protect a person from being subject to torture or inhuman or degrading punishment or other treatment. Where the sentence is not executed before the expiration of the said time, the sentence must be commuted to a punishment to be determined by the court, having regard to the guidelines set out in Section 39 and 41 of the Penal System Reform Act. So, in my lead-up, before I got into the meat and bones of the particular amendments, I had indicated that the precedents had leaned towards suggesting it was unreasonable to keep a person on death row for more than 5 years. And our amendment seeks to codify that, to take it out of the realm of suggestion and put it firmly into law, that we must get our system, our court system, in order such that we are able to properly prosecute matters, and the court system must be efficient enough to take a person from sentence to the exhaustion of his last appeal within 5 years. If we, as a government, and the Chief Justice, as the leader of the court, the Chief Administrator of the courts, cannot manage to get our court system running to a point where a man can have all of his appeals exhausted and heard within 5 years, then that sentence must be commuted from a sentence of death to something else. And the court gets to look at what that something else is. The other thing, Section 2.4 enables the court to impose a sentence of imprisonment for life on a person convicted of offense of murder. The CCJ has indicated in the case of Gab versus the Queen that a sentence for imprisonment for life should not prohibit the possibility of parole. If the provision does so, it is unconstitutional. So, Section 2.3 provides for the imposition of a sentence of imprisonment for life on a person convicted of offense of murder, but allows the court to set a minimum time that must pass before the person be considered for early release. When we watch the same court movies on TV and they hand down the sentence, they say a sentence of life imprisonment without the possibility of parole for very heinous crimes. Or they sentence you to 30 years, but you cannot have a parole hearing before 10 of them have expired. It gives the judges, the judiciary, a chance to reevaluate and make recommendations based on the progress of the person. Our penal system is not meant simply to punish people. We also look at rehabilitation of the offender. We look at compensating the victim. So if one of our factors is the rehabilitation of the offender that we have to take into consideration, it is not simply good enough to tell a man, I sentence you to 30 years and don't look back at him for 30 years. Imagine in that 30 years, that man has been the model prisoner. He has saved a life. He has found the Lord. He has written books. He is publishing from the prison inspirational messages that are keeping young people off. He's participating in prison programs aimed at trying to convince young people to stay out of crime. Then there should be some avenue to look back at that man's sentence and say, although you were supposed to be there for 30 years, based on everything that you have done, we think you might be good to go home after 20 or 15. It has to be a necessary factor. Otherwise, what incentive is there for anyone who enters the prison system to try to do better? If I have to serve out every day of my sentence without the possibility of the circumstance of my incarceration being taken into account, then there is nothing at all there that would motivate me to try to help a young person in prison. There's nothing there that would motivate me or inspire me to try to be a big brother to somebody else. And imagine if I can help 10 people in jail who might have passed through from minor offenses to turn away from crime. And I'm so committed. Imagine how much better I can do on the outside before they actually reach the jail. So all these things have to be factored. So I welcome and applaud the steps that we are taking, because it goes with the shifting concept of sentencing. It is no longer the Moses law. It is no longer simply an eye for an eye or cut off the hand. It is you are sentenced, but within the parameters of your sentence, you can work to try to do better. And we have to recognize when you have actually tried to do better and when you have actually done better. Also under the Offences Against the Person Act, there's provision in here, Mr. Deputy Speaker, that for all persons who were convicted, who were sentenced to death prior to the passage of this legislation, if we are now saying that the death sentence is unconstitutional and the mandatory death sentence is inhuman and degrading punishment, we can't simply change the law now going forward. If it is unconstitutional, it's unconstitutional. It's not unconstitutional going forward. It will have to be unconstitutional to those who are already under sentence of death. So the Offense Against the Person Act makes provision as well that all death sentences have now to be commuted, and the persons under the sentence of death have to have those sentences reviewed and the appropriate sentence given. Now, prior to this amendment, I think the only discretion that there was in the Mercy Committee was to commute, Her Majesty's Privy Council was to commute death sentences to life imprisonment. I'm seeking clarification from the member for Christchurch South. I believe that was the only discretion, to commute death sentences to life in prison. So, bearing in mind that there was no discretion other than commuting from death to life in prison, where you have actually been, your sentence has been commuted from death to life in prison, now with this amendment, you also have the opportunity to have your sentence reviewed and the appropriate sentence put in place. So everybody who was once under a sentence of death, whether it has been commuted to life imprisonment or whether you're still under death sentence, with the passage of this legislation, everyone will have their sentence reviewed. It will be, the death sentence is off the table for all you who have been sentenced before this amendment. And your sentence will then be reviewed as to whether it should be life or whether it should be something else. That, Mr. Deputy Speaker, is pretty much the nuts and bolts of the Offences Against the Person Act. The thing is, it does not stand on its own. We necessarily need to amend the Constitution, from which all the other legislation derives its efficacy. So we are seeking to amend the Constitution as well by deleting the provision in Section 15 that authorizes the mandatory imposition of the death sentence for the offence of murder, redefining the effect of the existing law clause in Section 26, and refining the exercise by the Governor General of the prerogative of mercy. So I will take us through, not that many, I'll take us through the amendments. Section 15 of the Constitution, the existing Constitution, is repealed, is deleted, and the following is substituted. No person should be subject to torture or to inhuman or degrading punishment or treatment. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, to the extent that the law in question authorizes the imposition of a death sentence or the execution of that sentence, or the holding of a person who is in prison or otherwise lawfully detained under conditions or arrangements prescribed by law under the Prisons Act, or under any other law pending the execution of the sentence of death in accordance with any other sentence of the court. I think that's pretty much self-explanatory. Section 26 of the Constitution, which is the existing law clause, has also been amended that the existing law shall continue to be enforced but shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring it into conformity with sections 12 to 23 of this Constitution. That is also self-explanatory. The prerogative of mercy now reads, that is section 28, clause 28 of the Constitution, the Governor General may, in Her Majesty's name or on Her Majesty's behalf, grant to any person convicted of an offence against the law of Barbados a pardon, either free of or subject to lawful conditions. Grant to any person a respite, either indefinitely or for a specified period of time, from the execution of any punishment imposed on that person for any offence. Substitute a less severe form of punishment for that imposed on a person for any offence, or remit the whole or part of any punishment imposed on a person for an offence, a penalty or forfeiture otherwise due to the Crown on account of such an offence. The Governor General shall, in the exercise of the powers conferred on him by subsection 1, or any other power conferred on him by any other law, remit any penalty or forfeiture due to any person other than the Crown, act in accordance with the advice of the Privy Council. Where a person makes a submission in accordance with subsection 5, in respect of offence against the laws of Barbados, the Governor General shall cause a written report of the case from the trial judge, together with such information derived from the record of the case or elsewhere as the Governor General may require, to be forwarded to the Privy Council, so that the Privy Council may advise him on the exercise of the powers conferred on him by the subsection 1 in relation to that person. A person has a right to submit directly or through legal or other representative without representation in relation to exercise by the Governor General or the Privy Council of any of their respective functions under this section. And a person may, in appropriate circumstances determined by the Governor General or the Privy Council, be granted an oral hearing and may make oral submissions directly or through a legal or other representative in relation to exercise by the Governor General or the Privy Council of any of their respective functions under this section. What that section actually effectively does is repeal and replace section 78 to remove the Governor General's capacity to direct that there should be time limits within which any person may appeal to or consult any person or body or person other than Her Majesty and Council outside Barbados in relation to an offence. So the time limits are necessarily addressed in the Offences Against the Person Act, which I went through before, and effectively suggests that if you don't execute the person within 5 years from the time you sentence him, then it can be commuted. That was pretty much the crux or the import or what informed all the other time limits with respect to appealing to the other bodies or to the Supreme Court or to the Court of Appeal. The Penal System Reform Act as I indicated before, there are certain sentencing guidelines that the judge has to take into consideration. The Penal System Reform Act is what the lawyers use as a mitigation, the law relating to mitigation for their clients. They look at the Penal System Reform Act and the criteria that the judge is supposed to take into consideration, and then they would mitigate for their clients based on the provisions of that piece of legislation. So we have to amend the Penal System Reform Act in order to give efficacy to the amendments within the Offences Against the Person Act and also the Constitution. The sentencing guidelines set out in sections 31 and 41 of the Penal System Reform Act apply to offences, the sentences for which was discretionary. The new Offences Against the Person Amendment Bill will change the status of the sentence for the offence of murder from one that is fixed by a mandatory sentence to one that is discretionary in nature. Thus, the sentence imposed for murder can be tailored to fit the circumstances of the case and the individuality of the offender. As a consequence, the aforementioned amendment, it was determined that it was necessary to amend sections 31 and 41 of the Penal System Reform Act to ensure that they apply appropriately to the offence of murder. I would actually have listed most of the criteria in my address on the amendment to the Offence Against the Person Act, but section 39 says that the court is bound to consider certain mitigating factors. Nothing in this act prevents the court from mitigating an offender's sentence by taking into account such matters as, in the opinion of the court, are relevant considerations with respect to the mitigation of a sentence, including. So what I'm about to list here are the factors that the court should consider before passing its sentence. So these can mitigate you down from life imprisonment to something else. The age of the offender, the particular circumstances of the offender, such as his social or economic circumstances, whether the offender pleaded guilty and the point at which the guilty plea was made. I pause here for a second. It is standard, and it has been the law in Barbados and in the common law, that a judge is bound to take into consideration in passing sentence a guilty plea because it shows that the person acknowledged their mistake and exercised some contrition. What the judge also has to factor is the time at which that plea is made, because an accused person could change his plea to guilty at any point in time in his trial before the verdict is pronounced. What the court factors is, if I as the accused person, and sitting down there thinking to myself, I could probably get off of this, and then I realize that 15 witnesses coming up, all of who say they saw me, and then the last one was actually my mother, who said, yeah, trust me, I saw him, it was him. And I then decide, okay, well, if my own mother testified against me, there's no way of getting off, so let me ease in my guilty plea quickly. While the court may take that guilty plea into consideration, it obviously does not carry the same weight as, for example, the youngster that I spoke about who had the 14 convictions, who had the 14 charges, who on the first occasion before the court pleaded guilty to all of them. So there's a difference to be considered there. And the amendment to the section codifies that. The circumstances or facts of the offence and the degree of the offender's involvement in the offence, and any attempt by the offender to make reparation for the offence. Now, our laws try to achieve equality in sentencing or in sentencing for offences. So, what had What used to happen, sir, was if 4 of us, actually let's not say 4 of us, let me not impute myself in criminal behavior. If 4 people set out to rob a man, and 1 man had a gun, and I went there intending to get a watch from off the man, but I didn't want to hurt him. And as we struggling to get off the watch, my partner, you see, I about to put myself in it, so I can put myself in and call some names too. So if myself, the member for St. Philip West, the member for St. John, and the member for St. Michael West, I put in leader opposition in it too. If we settle on a criminal enterprise, and somewhere in there, all of us were going to rob a man, but none of us knew, for example, that the member for St. Michael West had a gun, and the man then got shot and died. What would happen normally is something called joint enterprise. The law said we all set out to commit a criminal act. At the end of the day, somebody died. All of us are guilty of murder. This is why I would never hope to see the member for St. Thomas on a jury. But what this says now is that it looks at the culpability of each offender separately. So in this circumstance now, instead of all of us being found guilty of murder, it might be the member for St. Michael West who might face that by himself, while the member for St. John, who actually drove the car but didn't know we were going to rob anybody, he knew we were up to no good, but he didn't know what was going to happen, he might get off. While myself, I'll be getting off with him. And the member for St. Philip West might have to do 10 years with the possibility of parole after 5. So you see how we're now harmonizing it to bring it in line with the modern thinking with respect to penalizing for offences. And I will also show how this corrects some anomalies. In the same case of Joseph and Boyce that would have gone to the Privy Council, there were 4 young men who were charged. Well, I can say the facts. The facts are there. They're a matter of record. There was a young man, the deceased man, I think his name was Hippolyte. He had, the facts borrow that he had seen these men on a bus, and seen one of them on a bus, and he threw a rock in through the window of the bus. The man got up and went looking for him. And they found him, and they started to beat him. Somebody throwing some kicks, then somebody picked up a piece of board and hit him with it. But they left him there. But he got up within their sight, and he went to a house for help. So they watched him walk away and go to that house. He subsequently succumbed to his injuries and died. 2 of the men pleaded guilty, took the plea for manslaughter and pleaded guilty, while 2 sought to fight the case because they believed that they were the least culpable in the whole thing. So what ended up happening was 2 of the men, I believe, got 12 years, got a certain amount of time, and 2 of them are sentenced to death. So it cannot be that we have these anomalies. We need to correct our legislation that removes these possible anomalies. Because in a situation where those 2 men took a plea and got 12 years or got sentenced for the manslaughter, now with the court hearing the whole matter through, and the court hearing that maybe these 2 men who actually fought the matter were not the most culpable and actually should not be sentenced to death, the court now will be able to say, let me adjust their sentence, or let me sentence them that it does not create a disparate situation with the sentence of the other 2. as the law stood before, once they were found guilty of the murder, that discretion was gone from the judge. So you had 4 men in one enterprise. 2 men plead guilty and got a term imprisonment, and 2 men were sentenced to death. So this corrects all of that. So the judicial sentencing guidelines are explained, but these are the same. All right, so in sentencing the offender, the court should take into account the following guidelines. So not this, you address your mind to the mitigation first. So you check off your mitigation points, and then you address your mind to the sentencing. In sentencing the offender, the court shall take into account the following guidelines: the gravity of the offense and the need to hold the offender accountable for the harm done to the victim and the community by the commission of the offense. Any written representation made by a spouse or relative of the deceased in respect of murder or manslaughter, and in any other case, any written representation from the victim. So this allows those affected, either the victim or his next of kin or whatnot, to actually have a say to make representation before the sentence is passed for the judge to take it into consideration. It works 2 ways. Because in an offense, let's say of, let's take it from murder, let's say of wounding. If the family comes forward or the victim comes forward and gives evidence and says, look, although he pleaded guilty, so the fact's not before you, this man stalked me and followed me, and he beat me once, and he beat me again, and I went to the police, and then he followed me again, and then he beat me, and we know here. The court can take that into consideration. But equally, the court can also take into consideration like what happened that I had alluded to with the robberies, that the victim says, I don't want him to do time on my behalf. So this now is included in the sentencing guidelines. Ensuring the court must also ensure that the gravity of the sentence is commensurate with the nature of the offense committed by the offender. So that as well flows with respect to murder. That is the ultimate case where the sentence is commensurate with the actual offense. Because if I chop off your hand and I get time for it, I mean, my serving 5 years cannot replace your hand. But the ultimate sentence of taking a life to satisfy the fact that a life was taken is factored here as well. And it has to necessarily be factored to give, once again, effect to the fact that we're having levels now of murder. So the judge can factor that into, was this crime so heinous that the only answer is the ultimate sentence? Or if you go for lesser sentences, is the crime so heinous that the person should get at the maximum end of the scale? The judge must also factor the need to deter the offender and others from committing similar offense. So that's when the judge institutes a sentence to send a message. The manner in which the offender executed the offense and the nature and duration of the relationship between the offender and the victim, that is self-explanatory. That would normally factor in a circumstance. For example, if a parent is abusing a child or an uncle troubles his little niece or something. The degree and culpability of the offender and the maximum penalty prescribed for the offense. This is likely to be applied in cases where there are more than one offenders, and rather than pay everybody the same brush, you separate them as to their involvement in the crime. Any attempt on the part of the offender to make reparation to the victim or the victim's family, we're looking as part of our sentence to order also a compensation regime, because the reality is, if the member for St. Philip West cuffed me in my face, I may prefer to take $10,000 from him as compensation for the injury and my embarrassment than seeing him go to jail for a year. So it will allow for that. The need for rehabilitation of the offender and the need to promote a sense of responsibility on the part of the offender for the harm done to the victim. This one is directly to the offender. The need for consistency in sentencing in respect of similar offenses. And it should be the case that a person facing a charge or facing a trial should be able to predict the sentence he is likely to get. If I know that somebody broke and entered a house and stole a bed and they got 2 years, then I should also know if I stole the bed that I'm looking at 2 years. As opposed to one judge gives 2 years, and another gives a $1,000 fine. And the possibility of providing restitution for the harm done by the offender. That is self-explanatory. I'm coming home now, I'm soon there. The last bill we look at is the amendment to the Criminal Procedure Act. And the short form of this, the amendments that we are seeking makes provision, it creates a new section 6A which makes provision for a person who is to be arraigned upon an indictment for the offense of murder to undergo a psychiatric evaluation to determine whether that person is fit to plead. As it stands now, that is not in our law. But because of the ultimate sentence, you have to make all the necessary safeguards. So any person who is supposed to be arraigned and face a trial for murder, the court must send that person now for a psychiatric evaluation. And clause 3 inserts a provision to allow judges to intervene where the defense of insanity and diminished responsibility should be raised in relation to an accused. So where a judge, this one bears listening to because it allows the judge to interject and intervene and effectively interrupt the course of the trial. Where a judge determines from the circumstances of the case raised before him that the defenses of diminished responsibility or insanity should be raised in relation to an accused, the judge shall order that the accused undergo a psychiatric evaluation to determine whether the mental status of the accused would support the submission of arguments for diminished responsibility or insanity in relation to that accused person. Where the results of the psychiatric evaluation referred to in subsection 1 indicate that the defenses of diminished responsibility or insanity should be raised in respect of the accused, the judge shall ensure that the defenses are raised in relation to the accused. So what this says is where a judge is hearing a case and it becomes obvious from the evidence before the judge and from the disposition and the presentation of the accused person that that person is likely suffering from a mental disability or does not have full mental capacity, then the judge can order that they be evaluated by a psychiatrist. If the psychiatrist then finds that the person is of diminished responsibility, it will be unfair to allow the case to continue as if the person was a fully whole person, because they may not be able to defend themselves properly, they may not have been able to give proper instructions to their lawyer, and in keeping with trying to balance the rights of the accused as well as the rights of the victim, it is necessary that the judge retain the discretion to intervene in there to ensure that all defenses available to the person are raised. So, Mr. Deputy Speaker, I am sorry that I have taken this long. Actually, I'm not sorry. I'm not sorry at all. It was necessary, Mr. Speaker, for me to take this long to present this bill and these amendments. Because, as I said, it is not sufficient that these amendments pass if people do not understand what has happened. Let it not be that the public of Barbados leaves this hearing or switches off at the end of our debate and believes that the death penalty has been abolished in Barbados. It was also necessary, because of the nature of this debate, to take us through all of the other pieces of legislation that might be impacted, because the consideration of the mandatory death sentence occurs in many different pieces of legislation, ultimately with the Constitution. But it is not sufficient to just take it out. You have to take it out, but still empower the judges to make other determinations. You have to take it out, but still direct the judges as to mitigation circumstances. You have to take it out, but also adjust the discretion and the remit of the Mercy Committee. So it was necessary for us to go through all of the pieces of legislation so the pieces drop into place. At the end of it all, and after the successful amendment of all of the relevant pieces of legislation, the net effect will be the following. The mandatory death sentence in Barbados will be abolished. On a finding of guilty of murder, the judge will have a discretion as to what sentence to apply and guidelines for consideration as to how to arrive at that sentence. The judge will therefore have the option of sentencing the offender to death in the most heinous and egregious of circumstances where there is no other penalty under our law that will satisfy the balance of the victim, the society, punishment, retribution. Having consideration for all of the factors which must be taken into consideration, the judge can decide that the only sentence that suits this particular crime, because of its nature and because of the behavior of the accused person, is death. But the judge also has discretion where he finds that the circumstances do not warrant a death sentence to impose some other sentence. Because we are making the amendments now, they will necessarily affect some of those or some people who are currently under a sentence of death. So where a convicted person was under a sentence of death, whether he's still under the sentence of death or whether his sentence of death has been commuted to life imprisonment, that person is now entitled or must have their sentence reviewed, and the judge reviewing the sentence must apply the guidelines that were specified in the legislation. We have now brought our laws in conformity with the bulk of the human rights conventions, and also we have brought our laws in harmony with the decision of the Privy Council in the most recent case of Nerve, so that while we retain the right to sentence someone to death, it is not automatic, and the other factors have to be taken into consideration. And we also acknowledge and uphold in the Constitution the rights of the individual to be protected, have their rights, human rights protected from arbitrary, unreasonable, inhuman, and degrading treatment. So what we are putting before you today is the amendment to the Offences Against the Person Act, along with the reasoning and rationale for the amendments of the other act to harmonize those, so that our laws, our written legislation, will now come in conformity with the law as it now stands, following the decision of the CCJ, which is our highest court in the land. I hope, Mr. Deputy Speaker, that those who are listening now have a fuller appreciation and understand why we are doing what we are doing, that it is necessary, that it is correct, that it is appropriate. I want to thank the drafters of the law, because in addition to the drafting, the explanatory memorandum at the back of the legislation is perhaps some of the most thorough explanatory memorandum I've ever seen in the back of legislation. And anybody who chooses to go on our website, Parliament of Barbados website, you can pull up the legislation. You can actually read the explanatory memorandum for yourself, which is at the back of the legislation, and it sets it out chapter and verse and explains why it was done and the impact of it. So, having said all of that, Mr. Deputy Speaker, I beg to move that this bill be read a second time.
Thank you. Member for Sir Michael West.
Thank you very much, Mr. Deputy Speaker. The honorable member who just took his seat, having addressed this honorable chamber, is reputed in Barbados and in the region as a very highly skilled legal practitioner before the bar. It's regarded by many as a very good orator. I heard that comment this very morning from someone who just noticed him in passing. But he's a very poor judge of character, Mr. Deputy Speaker.
In what way?
In what way? Well, he introduced this hypothetical scenario of four of his colleagues, three of his colleagues, four of us in this honorable house, who embarked upon some imaginary crime. And he sought to put the gun in my hand. He must be a very poor judge of character. Because I think he included the Honorable Member for St. John in that four, and the Honorable Member for St. Philip West in that four. And I think he included himself. But yet he put the gun in my hand.
He put the gun in your hand.
He's a poor judge of character. Obviously, the presentation was intended to not only introduce these very important amendments to our existing legislation, but the presentation was attempted in a way to ensure that the Barbadian public became fully seized as to the nature of the action being undertaken by the House today, and the intentions of the government with respect to these amendments, and I think effectively presented. Obviously, a move, Mr. Deputy Speaker, to conform to the emerging laws, the emerging trends with reference to the practice of judicial matters in the region and even beyond. The attempt to amend the Constitution to provide for the discontinuation of a situation where there is imposed a mandatory sentence upon conviction, a mandatory sentence of death upon conviction for murder. The amendment to the Constitution to give effect to that occasions, as we have been well informed, other related amendments, penal system reform, criminal procedures, offenses against the person act, and stuff like that. So it is clear the context in which the amendment is being attempted from a legislative perspective. 2/3 of the established and recognized states of this world have not carried out a death sentence in about a decade. So there is a trend to move away from capital punishment as a mandatory sentence in response to a conviction on murder. More than half of those states have abolished the death penalty entirely, altogether. The understanding here that this is not the case in Barbados, this is not what is being done. We are removing the mandatory death sentence upon conviction for murder. In the buildup of case law in the region, and much of it cited by my learned friend from Christchurch East, suggests that the mandatory sentence of death upon conviction for capital murder breaches the constitutional provisions in relation to human rights and in relation to the right to life. These things are enshrined in our Constitution and have come under scrutiny and challenge, and now successfully so. Hence, we are here today in order to effect these necessary changes. Those trends, those developments with respect to the advance of the judicial practice across the region, the decisions which have been handed down thus far, some of which were alluded to by the honourable member who last spoke, highlight the inconsistency of that mandatory sentence as a penalty for murder when put against the matter of prohibition of inhuman and degrading treatment, prohibition of human and degrading treatment. All we are trying to say here from this position is that we understand what this government today is trying to effect in this parliament is in keeping with trends with respect to the dispense of justice across the region, and specifically in relation to the capital crime of murder. Ultimately, our highest appellate court, the Caribbean Court of Justice, has ruled in the case cited by the honourable member for Christchurch East and the lead spokesman on this presentation today, that that mandatory death sentence, in fact, does contravene the right of convicted capital offenders to the protection of the law, since it denies what is considered to be a critical, essential in the dispensing of justice, that is, judicial discretion. And hence, as I understand it, we want to provide for judicial discretion upon the ruling of the Inter-American Court. I took note of that. And Article 4 of the Convention of the Inter-American Commission on Human Rights, which addresses the issue of arbitrary deprivation of life, suggests that I think he may have referred to some of this. I quote some of it myself, Mr. Deputy Speaker. In Barbados, the purpose of statutory and common law defenses and exceptions available to defendants in death penalty cases is to defend the innocence of the defendant, not to determine the appropriate punishment once the defendant has been convicted. Though defendants have the right to apply to the executive branch for amnesty, for pardon, and for commutation of sentence, courts still have a responsibility to impose the most appropriate punishment for particular crimes. This is taking a position against what obtains in Barbados even until now, until this legislation before this House comes into effect. And Article 4.2, limitations on the death penalty of the Convention, reserves capital punishment only for the most serious crimes. Section 2 of the Offences Against the Person Act contravenes the Convention because it requires the indiscriminate application of the death penalty as punishment for conduct that can vary tremendously, as my honourable friend tried to illustrate. The imposition of a mandatory death sentence in the case of the Costa Cadogan, therefore, violated his right to life. And this is the document related to that document for which my honourable friend had quoted. But arguably, Mr. Deputy Speaker, I would also want to put on the table and in the mix for balance that though those who are found guilty of murder perhaps should not find themselves mandatorily faced with a sentence of death because certain rights are enshrined in our Constitution and other bits of our legislation that guarantees them right of protection and right to life and safeguards against degrading and inhuman treatment and all of that. Arguably, we must also consider that these things must be subject to the rights and freedoms of others. Because at the end of the day, we must never lose sight of the fact that no matter what my rights might be as constituted legally, when I infringe on the rights of others, I imperil myself and run the jeopardy of losing some of those rights. And I'm just trying to say that while we discuss this and while we understand where these trends are taking us and why we're here today and doing what we're about to do, we also have always to ensure that we do not lose sight of the fact that my rights are not at the expense of the rights of others. So he who murders may be subject to some rights and safeguards despite murder, however we qualify that murder. But he who murders and is subject to that qualification must also bear in mind that those who are victims are also also do have rights, and we should never lose sight of that as a society. The right to life, the right to liberty, the right to security. Now, we understand that we must make an amendment to Section 2 of the Offenses Against the Person Act, and that will have to be amended to accommodate removal of the mandatory death sentence and to provide for expanded sentencing options. I think that is ultimately the intention. Now, I support strongly and wholeheartedly the Cabinet's insistence that we retain the option of the death penalty. And I simply seek to reinforce what the honourable member tried effectively, I think, so to do, that Barbadians understand that we are not about abolishing the possibility of a sentence of death and conviction for capital murder, simply expanding the options. Now, often, Mr. Deputy Speaker, the question is asked, is the death penalty really a deterrent? Now, there are many who come from the church who strongly believe that we ought not, as a modern society, a modern state, to have on our statute books capital punishment of death, even for the most brutal murders, because they attach a sanctity to life which they believe overrides the state's authority to take life itself. And they take a negative view of any society or state authority which seeks to retain and exercise that right to take life as a punishment, as a sentence for the commission of capital murder. But I have a very simple view, Mr. Speaker, as to whether it constitutes a deterrent or not. They say the statistics, when you research them, will say it does not. They say if you check in any region of the world, you find that capital punishment does not deter persons from committing murder. Well, I don't know about that. I have a very simple view of this matter, Mr. Deputy Speaker. And if I know well the honourable member for St. Thomas, I am sure she will concur. A very simple philosophical frame within which I look at these things. There are those who will commit murder, whether or not there is a death penalty. And so death penalty will not deter them. There are those who will not ever commit murder under any circumstances. So the death penalty sanction does not apply in their situations. But I'm sure you will agree with me, Mr. Deputy Speaker, there are those who, were there not a death penalty, would commit murder in given circumstances, and that the death penalty serves as a deterrent for them, and those we must deter. There are only three types of persons: those who will kill no matter what, those who will never kill no matter what, and those who will kill were they not deterred from so doing by the retention of a death penalty. So I support strongly the view of the Cabinet that that must stay in place as an option of sentence for the court. And if ever we feel challenged strongly to remove, as a government, as a people, the death sentence in response to conviction for murder, that it be made the subject of referendum in Barbados. That's one of the things I do not think that 23 or 26 or 15 people in the cabinet room should decide. It's not something that 30 people in an honorable chamber such as this is, however configured, whether 29-1 or other, I do not think that that kind of issue should be settled in that context. and that therefore, if ever there is such pressure from the outside, internationally or regionally, if ever there's such a push from the inside, locally, that we abolish totally the availability of the capital sentence to the court, that we make that a subject of referendum. But, Mr. Deputy Speaker, we need to do the necessary. When people are convicted of murder, especially under the anticipated context where mandatory death sentence does not now apply, we need to make sure that we do things in such a way that those, very strong on this too, those who attract the ultimate sentence, the mandatory sentence from the court, when all things have been considered, that we put our judicial process, our judicial architecture in such a state, put it in such a state, get it in such a state that we can expedite the matters of justice quickly as possible. All I'm saying, it is good that as a society in this modern day, progressive as we are, we can come to this chamber and effect such changes as would remove those stipulations which we believe impinge upon the rights of persons, even those convicted of murder. But even as we do that, when once a person attracts the mandatory sentence attracts the maximum, the ultimate sentence from the court in relation to this crime, we need to make sure that we expedite execution of that sentence in a sufficiently proper time, as that we do not make a nonsense of the courts and of the process of justice in Barbados. We all know where it started for us with the Pratt and Morgan case of several years ago, and they have parts of that here to which I want to refer because it's a serious thing. And all I know, we live in the face of the consequences of a system of justice unable to carry out sentences determined by the court because we do not ensure that mechanisms to effectively and appropriately, quickly expedite these matters are in place. On the 9th of July, 1987, the Inter-American Court of Human Rights, pursuant to further representations of Pratt and Morgan, informed the Jamaican government of the following findings. Pratt and Morgan suffered a denial of justice during the period 1980 to 1984, violative of Articles 5.2 of the American Convention on Human Rights. That's the position they took. Commission found that the fact that the Jamaican Court of Appeal issued its decision on December 5th, 1980, but did not issue the reasons for that decision until 4 years later, September 24th, 1984, was tantamount to cruel, inhuman, and degrading treatment because during that 4-year delay, the petitioners could not appeal to the Privy Council and had to suffer 4 years on death row awaiting execution. The Trinidad government, some years ago, put in place a management commission intended to serve as a mechanism to expedite these matters, so that once a sentence is given at court and the accused is allowed all of his appellate rights and the processes are gone through, the judgment of the court can stand and the sentence can be carried out. You are old enough, Mr. Deputy Speaker, to remember this. That is why Dole Chedi and his gang are no longer with us, because the Trinidad government, the state, moved as quickly as possible, put mechanisms in place to expedite the sentences handed down in the court. So we're going to expand the sentencing options, and we're going to provide for relief for persons in consideration of their rights and so forth. We also have to so equip the system and so expedite matters that once appellate rights are exhausted, the sentence of the courts can be carried out, and people, some elements in Barbados will not be of the view, I can kill because all I gotta do is go up there after a while, 10 years, 15 years, get fed, and come out. And that is part of the thinking that obtains among certain elements in Barbados. We need to improve the technical capacity of the courts, and we need to remove all the obstacles to efficiency so that justice can be dispensed evenly, fairly, but as swiftly as possible. Justice delayed is justice denied, not only to victims and not only to offenders, but to the entire society. And that is the terms in which I see things, Mr. Speaker. That when the offense of murder is committed, it's not just one individual against one individual, but it is an action against the state, against the society, against our domestic humanity, if I may put it like that. And therefore, those things may be seen, must be seen in those terms. I have to ask, and I do not know who is equipped to answer, but where are we with forensics in Barbados and legislation relative to the use and employment of forensics? Where are we in Barbados with reference to the matter of the use platforms for DNA and the legislative framework among maybe the legal minds on the other side can tell me, and perhaps by extension tell the public, because we take stress from the world. We are made sometimes to address ourselves to those trends introduced by them, and pressure is put on us to comply and conform. And that is part of the world system. That is where we are. That's the nature of life in this world for states today. But I also think that we need to take cues from them as to where they have gone in improving and better equipping their justice and law enforcement systems. So my question really is, where are we in Barbados today, both with respect to the legislative frameworks and the use platforms for things like forensics and DNA? Now, I do not know, Mr. Speaker, that we can continue for much longer simply relying on, if that's what we're doing, as seems to be the case, on witness-provided evidence. No, we have to get real, Mr. Speaker. We have to get real, Mr. Deputy Speaker. The role of witness, or reliance on witness evidence, is something we've got to look at. We're a small society. Everybody knows just about everybody else. The Honorable Member for Christchurch East is even aware that I have a gun. I wasn't even aware of that. So everybody knows everything about everybody else. And we know what's happening in our society, Mr. Deputy Speaker. And there are some people who are very unwilling to come forward and say anything in the face of certain crimes, or in the first face of crimes committed by certain types of perpetrators. And so there is a disinclination to come and say what I saw, to come and say what I know. Because if I speak against him, if I speak against her, if I go to court and talk in this frame, they know me, they know my family, they know my children, they know where I live, they know where I hang out. And so there's a jeopardy, there's an exposure. We must get beyond that point where we have to exercise a measure of reliance, which we now do, on witness evidence only. Hence my questions: where are we with respect to the use platforms and the legislative frameworks relative to DNA and forensics and all that? I don't know. You guys need to tell me and to tell the rest of Barbados. But I think that these things are very important. The immediacy of the threat to witnesses, the capacity to bribe on the part of criminals and offenders, the vulnerability to bribery in the light of poor financial, economic situations affecting many people, very vulnerable to being bribed. All these things are realities that we have to deal with, Mr. Chairman. And we don't have, as far as I know, a situation which allows easily for witness protection. We don't have that facility. I mean, even in Trinidad, they do that, but Trinidad is not much bigger. Barbados, Jamaica, United States. But we need to be able to get beyond the degree of reliance which we now seem to have on witness evidence and employ some of the more scientific techniques in resolving crimes and responding to the criminal element. I have to ask the Honourable member for Christchurch East to clarify or expand on something for me. I'm referring to Section 39, the mitigating factors in relation to the Penal System Reform Act. At 39, he quoted these, Mr. Deputy Speaker. The mitigating factors include the age of the offender. I don't have a problem with that. But the particular circumstances of the offender, such as his social and economic circumstances. Taken at face value, I think I understand that. But it would seem to me that that language leaves some leeway. That language leaves some leeway for some discrimination in the application of that particular mitigating consideration. The particular circumstances of the offender, such as his social or economic circumstances.
Point out.
At the request of the Leader of the Opposition. Mr. Speaker, it starts by saying that nothing prevents the court from mitigating the offender's sentence by taking these things into consideration. So the court has the option to consider them or not consider them, or apply them or not apply them, but it needs to be aware of what they are. And it will be a counsel of prudence for the court to actually address its mind to each of these factors and then decide what weight it puts into it. This is standard language for similar clauses, and what it seeks to deal with. I understand where my friend, the Leader of Opposition, is going. I think that the circumstances of social and economic circumstance tend more to the lower end of the scale than to the higher end of the scale. So it will likely not be a situation where you get off because you are wealthy and come from a good home, so to speak, but rather that the court, in looking at your offense, for example, if you stole 2 loaves of bread, the court will be able to look at the fact that you stole the 2 loaves of bread and you had a family at home starving and a child that hadn't eaten. So rather than allowing abuses by those at the upper end of the social platform, it would allow mitigation and some consideration and compassion to be given to those who are otherwise disadvantaged at the lower end. I hope that has clarified that.
Very well. Member for St. Mike.
Thank you, Mr. Deputy Speaker, for allowing that point of elucidation from the Honourable Member of Christchurch East. And I understand what he's saying, and that is how I interpret and take this at face value. All I'm saying is there are some persons who, reading this, will alternatively interpret that to suggest that it speaks to privilege, perhaps, for fellows who are better off. We have had a recent instance in Barbados where we began to hear the howls of despair, the voices of recrimination, when it seemed as though there's a law, one for the Medes and another for the Persians, one for the Jews and one for the Gentiles. And all I'm saying is, this language here, falling on the wrong ears, may be interpreted to mean not what the Honourable Member for Christchurch just said, that the court now has to consider this as a mitigating factor, especially with reference to those who are at the lower end, but that the court can now, based on this, look at those who are on the... You agree with that, don't you, Mr. Deputy Speaker?
I'm agreeing with what you're saying.
You're agreeing, Mr. Deputy Speaker?
I'm listening.
Well, I thank you for listening. So, yes, Section 39, and of course, several other guidelines for judicial sentencing on Section 41. I'm not going to read them. The Honourable Member for Christchurch East went through all of them. And I believe that it constitutes a good, what do you call it, paragraph, a good section on guidelines to the court in terms of how officers of the court should conduct themselves with respect to sentencing. But, Mr. Deputy Speaker, we need to strengthen our justice systems, as I've been trying to indicate. We need to ensure better victim support in Barbados. We need to ensure better victim support in Barbados. In 2018, yes, we must be concerned that there are adequate sanctions for offences. In 2018, we must be concerned that we can provide for proper conditions in our penal institutions. All of this is good. But in 2018, we have to up the thing. That's what the people say. We have to up the thing when it comes to this matter of support for victims. And that's a serious responsibility of communities. It's a serious responsibility of the state. Because oftentimes the victims of offenses in Barbados benefit not at all in any way, significantly or in any way sometimes, except to see that justice has been served and somebody is being sent to prison for committing an offense against my person. But I believe we need to better facilitate victim support in Barbados. There are a lot of non-governmental organizations. There are a lot of registered charitable organizations in Barbados, the church not excluded, which are involved in support for victims, not only of poverty, but victims of crime. And the state has to facilitate that kind of work. We've got to make sure in Barbados that there is not only punishment for the offender, but that there's healing, there's remedy beyond what you get at the court for persons who are the victims of crime as well. And that is healing for communities as well. Communities suffer when some individuals suffer, depending on that degree of suffering and the nature of that suffering and offense. So we need to better ensure victim support. We need to better ensure non-discriminatory outcomes for what I call marginalized and minority groups in Barbados. We cannot shut our eyes. We cannot shut our ears. We cannot turn our minds away from the fact that there's a strong view in Barbados that depending on where you come from, depending on how you are profiled by Barbadian society, your exposure to the strictures of the court differ from those of people who are otherwise profiled. That is a reality. And I think a government worth its salt will face up to that squarely and try to address the matter of, even if it is only a perception, non-discriminatory outcomes at court, at the hands of justice, the justice system, for marginalized minority groups, those who live among the lower socioeconomic ranks in Barbados. We need, come back after lunch. I have to go bury the dead, you know, Mr. Speaker, Mr. Deputy Speaker. But if you give me two more minutes, Mr. Deputy Speaker, I will conclude this. Thank you very much. So we have to go there. It's not just about locking away people. It's not just about protecting the rights of people who commit murder and ensuring that there are options of sentencing. But it's a treat to victims. It's a treat to the system. Make sure the system is more expeditious in how it does its work, and make sure that there's a better provision, a better atmosphere, a better environment, a better deal for those who are victims of these various offenses. Mr. Speaker, we need to address factors of urban poverty. This administration historically has been noted, and in its last iteration was particularly reputed for taking a significant interest in the matter of urban poverty and addressing this urban poverty. And I'm saying this because social erosion, community scarring, urban poverty, high not only employment but levels of underemployment conduce significantly to crime in Barbados. And if you are going to address matters such as this, which require change in constitution, a change in so much of the rest of the legislative our framework and architecture, if you're going to do this, you can't lose sight of these other things. And all I'm saying is, if you're going to address crime, you have to deal with urban poverty, community scarring, community erosion, high levels of underemployment in Barbados. Member for Christ, for St. Michael East, will tell you this in glowing terms, far better, using far better language than I can, that you've got to address this. Because as long as you have this, you will have a problem of crime. We're preparing now to go into a harsh period of economic strictures, and Lord knows what that will bring in terms of its impact upon those who are already poor. And I'm not treating to that right now. All I'm saying is, if we address the justice system at this level, if we address matters of sentencing, the issue of capital punishment, and we change all of this thing, this is fine. But treat the victims as well. Facilitate groups that are involved in victim support, but also deal with issues that conduce to crime, like poverty, urban community scarring and erosion, and the like, and high levels of underemployment, which is really, really, really a serious feature in Barbados. I thank you, Mr. Deputy.
Mr. Deputy Speaker, I beg to move that this sitting be suspended for lunch until 1:45 p.m.
Question is that this session be suspended until 1:45 this afternoon. All in favor say aye. Those against say no. May the ayes have it. This House is now suspended until 1:45 in the afternoon.
As viscerally as the death penalty, there are several issues that pass through the public domain for discourse among people, But when one comes to the issue of the death penalty, it is normally an area in which one abandons political affiliation, one abandons narrow political interests, and personal and individual conviction comes to the fore. It was almost fascinating, as an example of that, to observe the exchange between the Honourable Leader of the Opposition and the Honourable Member for St. Thomas this morning, to whose contribution I eagerly look forward. But even at that level of exchange, there appeared between those two to be some commonality of thought and conviction on the issue of the death penalty. It may be that they belong to the same generation, and I'm not far behind. And I know that definitely they come to life and they come to this chamber with that sense of values that date back to a childhood which was stable, in which they were taught that law and order was to be respected. It clearly dates back to a time when authority was respected, and that was a time in Barbados in which the death penalty was taken as being the right thing to do in the event where a person was found guilty of murder, or indeed where a person was, in some cases, found guilty of manslaughter. There were people who still felt that a life was taken and that the only recourse was to take that person's life. That is not within my immediate contemplation this afternoon, Your Honor. I want to explore the legal and constitutional matters which spring from this amendment that is brought before the House. It is a matter of some regret that this amendment comes only because the Caribbean Court of Justice has given a ruling in a case called Nervais. I think that is the name. It is ironic that men who commit these very heinous offences normally have their names celebrated in parliaments and in legal discussions and law reports. They become celebrated figures, although what they have done is not worthy of any celebration. So I won't call the name again. But it is that case that has caused this Parliament to reach this point today. And I did say it is a matter of some personal and professional regret, because we ought to have been at this stage a long time ago. We ought to have been amending the law that mandated a judge to sentence a person to death when a jury said that that person had been guilty of the offense of murder. It has taken, now this is a new Parliament, so it is not to reflect on this new Parliament. But I cannot pass unless I criticize an earlier Parliament for its delinquency. As I said, we should have been here a long time ago. When we were celebrating 50 years of independence, we were still without all aspects of our sovereignty. And I will say what I mean by that. There's a section in the Constitution, section 26, and it is called ordinarily the Savings Law Clause. And I am addressing you, Your Honor, as much as I am addressing the public, and to give explanation to this so-called Savings Law Clause. When we received the Constitution in November 1966, that Constitution contained a section 26. That Constitution also contained a fundamental rights provision. In other words, that Constitution gave to the citizen the right to life, the right to freedom of association, the right to freedom of speech. It gave several rights and freedoms that we call fundamental rights. So that here was the Constitution in November 1966, given to every Barbadian citizen his fundamental rights, and that the state could not abridge those rights. They were fundamental. Every citizen had the right to the exercise of those rights, even against the powerful state. But here was the same Constitution at section 26, saying to the citizen that any law that was passed prior to 1966, any law that existed prior to 1966, which he felt, or which objectively it was felt, collided with or infringed any of his fundamental rights, that any law prior to 1966 remained good law. In other words, he could not challenge that law that existed prior to 1966, even if he felt, and even if the courts felt, that that law abridged any of his fundamental rights. And that is why we refer to it as the Savings Law Clause. It saved laws prior to 1966, even if those laws were in conflict with your fundamental rights derived under the Constitution. So here was a Constitution giving rights, and here was the same Constitution asserting to the citizen that any law prior to 1966 that collided with those rights remained good law. And the law that we've come to amend today had been one such law. That law was contained in the Offences Against the Person Act. Now, I said earlier that it really touches questions of sovereignty. Sovereignty being that right and capacity to govern the entire geographical area that is called Barbados. But I press on from that. And to indicate to you, sir, that looking at the Offences Against the Person Act more particularly, that act said what we all know it said, but let us say it again, that when a jury found a man guilty of murder, the judge had to. There was no choice. And I think the Honourable Member for Christchurch East explained it this morning. It was automatic. It was almost ritualistic. The jury finds the man guilty of murder, and the judge literally read the sentence. He had no choice in the matter. Is there not, or was there not then a sense in which the jury, those 12 men and women, were determining what was to be the sentence? Because a jury went into that case, a jury went into that jury box, knowing, having been told by the prosecutor, and they went into that deliberation as to a verdict knowing that a verdict of murder would result in the man's possible death. I submit to you, Your Honor, that there's a sense in which the jury was passing the penalty of death, was issuing the penalty of death, not the judge. The judge's role, in my view, in a very real sense, was ritualistic. He was reading what the law mandated him to read. And I submit that for this other reason. And to ask the question, when we come to amend the law, in the words of the Honourable Member for Christchurch East, when we come to amend the law, is there not a case for a further discussion as to whether the discretion to execute or not to execute, whether that discretion should reside with the judge alone or whether it should reside with the jury? I submit to you, Your Honor, and I say to the citizens of this country, that there are certain parts of the United States in which the system says that after a man is convicted of the offense of murder, in their jurisdiction it would be a first-degree murder. The jury, and this is only in some states, the jury then holds a separate deliberation. It becomes almost a separate trial. And it is the jury that has heard the case that then tries to decide whether the person convicted, whether the person that they convicted is due the penalty of death. I want to submit to you, Your Honor, and I want the public that feels very, very strongly on the issue of the death penalty to consider whether the responsibility, the heavy and final responsibility of passing a sentence of death should fall on one person, whether it should fall alone on the shoulders of a judge, or whether, as in some jurisdictions in the United States, that grave and weighty decision should be made by a panel of 12 persons, and whether that panel of 12 persons will be allowed only to pass that sentence of death if they are unanimous. As I've said before, Mr. Deputy Speaker, under the system that we are changing today at the urging of the Caribbean Court of Justice, in a very real sense, it was the jury that was not only convicting, but condemning that man to death. As I said, the judge's role was ritualistic. This amendment today places that entire responsibility on the judge himself. And I think we as legislators, we as parliamentarians, need to invite the public into this discussion, because this is a discussion that has no political borders. This is a matter of individual conscience, an individual conviction deriving from the state of one's value system. And therefore, the public must be and might be asked to consider whether, if in the event that they wish to preserve the death penalty, do they also wish to preserve that discretion in the hands of a single person who happened to have conducted the trial as a judge, or whether that heavy responsibility should find itself distributed among 12 persons acting as a composite whole, a jury, and that it would only after they have found that the person ought to be condemned to death, that they must do it unanimously. That's a heavy responsibility. And the public that invests so much emotional energy that the public ought to be engaged as to what is their position on it. Is it one man, or should it be a jury of 12 persons? As I said, Your Honor, this Section 26, this Savings Law Clause, I come back to it. The CCJ sitting a few weeks ago reminded this country, and in particular reminded this Parliament, that savings law, that Section 26 of the Constitution, should not hold a country hostage, or should not hold a country's legal system hostage indefinitely. Indeed, that court remarked that in Belize, when they introduced their independence constitution, their savings law clause was expressed to be for a period of 5 years. In other words, it was transitional. What the savings law clause does in Belize, and what it ought to have done in Barbados 50 years ago, was to have urged the Parliament to get busy. That any law prior to independence, which was unjust, any law that was ripe for amendment, the Parliament of the country was urged to amend that law, to change that law, to update that law, to modernize that law. And so, that Belize should not have found itself in Barbados' position 50 years after independence. The Belizeans say that that savings law clause will only exist for a period of 5 years. In other words, it was given the Parliament of Belize 5 years to put bad law right, to correct injustice within the legal system. We were around here, was it 2016? Making a song and dance about 50 years. When the Parliament of this country, at that time, should have been correcting unjust pre-independence law. But we prefer the party. We prefer the party, rather than to have an industrious Parliament fix the law that needed to be fixed. Another matter of, and before I press on, so that the CCJ said in that case that the Parliament of this country should get on with the business of correcting pre-independence law as it relates to this amendment, so that without diminishing on the efforts of the Attorney General has done what the CCJ is suggesting ought to have been done. And to that I add again that what is being done today ought to have been done a long time ago. And that we as legislators must spend our time looking constantly at law reform. There's so much law that needs reforming in Barbados. There's so much law that is antiquated. There's so much law that is irrelevant. There's so much law that needs to be updated with technological advances. Except that if that law, and I repeat, if that law had been pre-independence law, you cannot challenge it. If you felt that that law offended against the fundamental rights provisions. So that this law, we've been brought to this place by the Caribbean Court of Justice. And this Parliament must be even more industrious and on its own initiative must look at all those pre-independence laws which need updating. The case also highlights, Your Honor, the relationship between two arms of the state. The relationship between the judiciary and the parliament. I think the public needs to know that there are three arms of the state. When I say the state, I'm not talking about the government. There's always a time to explain to the public what is the state and what is the business of the state and why the state must exist. The state is that human community which has legal responsibility for the security of this entity that we call Barbados. That's the state. It's a human community. It is a collection of human beings. The state is not the government. The state is an entire human community stretching beyond the government. And that state gives power, or rather, power is given to three entities within the state. Those three entities, the legislature, this parliament, which includes, of course, the Senate, which has the responsibility and the sole responsibility for passing laws. Because we all exist under law. No one is above the law. That is why we talk about the rule of law. The rule of law implies that none of us, no living person in this country can function above the law. And so this parliament always has the responsibility for passing laws. And that's a serious responsibility, because when that law is passed, all persons become subject to it, and all persons must obey it. The judiciary, Your Honor, they will say to you, and they will say to the country, that they do not pass law, they do not make law. Some people challenge that. But it is their responsibility to interpret the law. And of course, the other arm of the state is the cabinet. And it is the cabinet that has responsibility for managing the day-to-day affairs of the country. And they do that by setting policy. They do that by executive action. Now, I refer to that relationship between the three bodies of the state to indicate, Your Honor, that not one of those bodies is superior to the other. Some months ago, when this parliament was differently constituted, I heard a member, since disappeared from here, saying that he would take action in relation to certain matters pertaining to the judiciary. Now, that statement was an unhappy statement. It was unconstitutional, for one. The legislature, neither the legislature nor the cabinet has any authority or supervisory authority over the judiciary. The legislature, that is to say the parliament, the cabinet, and the judiciary are equal under the Constitution of Barbados. They are equal. They have power. The power within one does not exceed the power within the other. Except, of course, that they're separate. Being separate, one is not superior to the other. The only supreme entity in this country, the only thing that is superior to those three arms of the state, is the Constitution of this country. Because all three of those arms of the state must function according to the dictates of the Constitution. And that is why we say, that is what we mean when we speak of constitutional supremacy. The Constitution is supreme. But we are brought to this place in this event today because the judiciary has ruled in this case that pre-independence law conflicts with the fundamental rights within the Constitution. The Constitution itself had said since 1966 that you could not challenge any law if it collided with the fundamental rights within the Constitution. The CCJ has departed from that. And that is what is so significant about this decision. The CCJ has departed from that. And the CCJ, it is the CCJ. One may even go as far as to say, perhaps the CCJ has taken a political initiative. And I want to say that many of us who describe ourselves as progressive lawyers may well agree with them. That 52 years into your independence, you cannot have your laws kept back by a provision in the Constitution that says you must keep all law. So it is the CCJ that has sent us here today on this, with this mandate that pre-independence law, if it is unjust, it has to be dismantled. What the CCJ has done, Your Honor, there's a sense in which the CCJ itself has promoted the dismantling of Section 26 of the Constitution. It is the CCJ that has promoted the dismantling of the Savings Law Clause in the Constitution. And as I said before, Belize long anticipated this situation, and they passed a law within their Constitution that their Savings Law Clause would last for only 5 years, and at the end of 5 years, it ceases to be of any legal effect. We've waited 50 years to do what the Belizeans had the courage to do when they became independent. Finally, Your Honor, the issue of punishment. As I said, there is nothing that touches public sensibility as much as punishment. I am willing to wager that we live in a country in which people are agnostic on things like the existence of God, things that it is said cannot be proved. I don't believe I will ever meet a person who is agnostic on the question of the death penalty. I can't say where the majority stands on it, but I know everybody in this country feels strongly about the death penalty. They feel strongly either for it or they feel strongly either against it. And again I say, this is a discussion, this is a debate in which the public must make that strong emotional investment as to whether we should continue with the death penalty. And we hasten to make the point to Barbadians that this amendment today is not abolishing the death penalty. It is not abolishing it. What this amendment is doing today is that this amendment is giving the judge, as the Honourable Member for Christchurch East said, it is giving the judge a discretion as to whether he or she will impose that penalty of death. I submit, Your Honor, it is a very heavy responsibility. A very, very heavy responsibility. I would not read exhaustively where the judge is invited to exercise his discretion, but it is obviously in extreme circumstances where it is heinous, where it really offends humanity. If you kill a baby, for example, it also aims, this amendment also aims to protect the very existence of the state. Where you kill a police officer, for example, where you kill a judge, for example, a judge has a responsibility for hearing a case of any nature. A lot of people leave the family court, and when they leave, you hear them. So many houses are burnt after the family court adjourns on Fridays. They're going to burn the house. They're going to burn the car. They might kill somebody. So that it is not only in the criminal court in which the judge becomes exposed to potential danger, but it is the court in every jurisdiction, and particularly in family jurisdiction. A lot of people leave there believing that they have not had their rights defended and they're going to kill somebody. And so, in the event that that threat is ever carried out, a future judge becomes entitled to consider that if that were the motive for the killing of a judge, I have no doubt that his lordship or her ladyship will indeed sentence the person to death for killing his brother or his sister. But I've asked the question earlier, and I will ask it again, so that the public may consider this. Is that heavy responsibility to be placed properly into the hands of a single human being, a sole human being? Or the persons who heard the trial, 12 persons sit in a room and hear an entire trial for 2-3 weeks. Then they sit and deliberate, sometimes up to 5 hours, so that they have a command of the facts. They have a better grasp of the facts than any other person. They don't derive their facts from gossip nor from social media. They derive their facts from what they heard in the courtroom in the form of testimony.
Member has 5 minutes more.
Thank you very much, sir. Is that body of persons, or should that body of persons participate in the imposition of the penalty of death? I remind you as to what I said earlier, Your Honor, that there are parts of the world, and I think in the United States, where the jury participates in the penalty. We are asking people in this part of the world to place that responsibility on the shoulders of a sole judge. And we looked at the various instances in which the judge may sentence a person to death, as I said, where, for example, he's killed a helpless child, where the person killed was a member of the police force. And let me happily say to the member for the city that this includes members of the defense forces, so that the amendment is aimed at protecting the very existence of the state. You cannot target your state officials. And if you kill your state officials, the inference is that you're trying to destroy the state. But then at the end, it gives the judge an even wider discretion. It says, in the opinion of the court, there are any other exceptional circumstances which must be taken into account and which justify the imposition of a sentence of death. Now, it is not for us to guess at this point as to whether this amendment will ever be employed in this country. The last time this country did it was on a sunny morning in June 1984. I remember a man indicating to the media that he went up there because he likes to hear the clap of the trapdoor. There are some people, death and punishment by death appeals to people in all kinds of weird ways. We like to be more dispassionate in matters of the penalty of death. But I will end by saying this, Your Honor, to you and to my colleagues and to the public of Barbados, just to remind that this is not a partisan issue, this is not an issue where there are political barriers. This is an issue of personal conviction, and that personal conviction may even find its basis in religious beliefs. It may do so. But to consider that even after this becomes law, that we must not leave it, Your Honor. That this Parliament must find itself in the not too distant future debating the question of a system of degrees of murder, as in other countries. I think that time has come. I think the time has come when the degrees ought to be extended beyond what we have presently. At this point in time, we only have murder and manslaughter. That is all we have. And to be honest, sometimes you get a sense that a jury believes that the verdict or the penalty for murder is so severe that what may otherwise be murder, they reduce to manslaughter. I'm not a prosecutor, but I will say this, that I suspect that there are juries who have found men guilty of the lesser offense of manslaughter simply because they don't want the man to hang. There are cases in which they may well believe that it fits within the category of murder, but they go for manslaughter as a compromise, which is consistent with my earlier view that juries in effect sentence, and that juries sentence by reducing murder to manslaughter if they don't want the accused man to hang. And so I think the time has come in this country, and I say this from a very personal position, that we ought to be introducing degrees of murder so that jurors have a clearer picture as to what they're dealing with. It could be first-degree murder, second-degree murder, third-degree murder, and beneath that manslaughter and the other homicides by misadventure and so on. But the point I make is that we have the opportunity, and I urge the Attorney General to move beyond this legislation and to progress the issue of the death penalty under the Constitution of Barbados, to progress it further, where men can feel that they're going to get a fair trial in the courts, and where the relatives of the deceased will feel that their matter is so respected that the system is willing to treat it with due respect. And I think that is the point we have reached. In the 30 seconds I have left, is it that or is it more than that?
Conclude.
I want to respond to something the leader of the opposition raised about forensics. We've had forensics around here for a long time, a very long time. Forensics have made murder cases a lot easier. I think the first murder case that relied on forensic evidence was done sometime around 2006. That is 12 years ago. So that we do have a forensic laboratory. It certainly has made rape cases a lot easier to deal with, because the man cannot say he did not do it if they prove that the semen is his. His defense then becomes reduced to that of consent. But a lot of men used to come to court and say, me, I did not me, I wasn't there. But forensic evidence can place him there, quite literally and physically places him there. So it reduces his defense and therefore promotes justice. So I want to assure the leader of the opposition that forensic evidence is alive and well in this country, and that it has saved the courts a lot of time trying to deal with people who dispose themselves to telling lies for the purposes of freedom. I suspect this debate will continue another time. I will end by urging the Attorney General to do what the past Parliament has not done, and that is to become industrious, to get busy with the laws of Barbados, to look at pre-independence laws, which are unjust, and to update them so that the Constitution is genuinely supreme. Because I say to you, Your Honor, that Section 26 denies the supremacy of the Constitution in which it is contained. We do not yet have a Constitution that is supreme if it allows pre-independence law to govern our modern reality. With that, I'm obliged to you.
Thank you. Member for St. John.
Mr. Speaker, I wish to participate in this debate for a couple of reasons. I am forced to drink from the chalice of forgiveness and leniency as it relates to this particular bill. And I must admit that I would have vacillated a lot on this issue, if not for the simple fact that I am the father of three. And the reality is that the Honourable Member for Christchurch East would have mentioned, and the Leader of the Opposition would have mentioned the mitigating circumstances as it relates to the punishment of the death penalty. And I want to take this opportunity to be pointed in relation of some of the areas, or one particular area that I believe would strongly factor into the mitigating circumstances. And if you look at the court cases, more often than not, you would see youngsters from a socio-economic background that speaks to struggle. And I want to be pointed here as it relates to parenting. And I'm not going to point the fingers at the females in Barbados, because I too could have gone in that direction as a product of a single mother. But I want to point the finger today, Mr. Speaker, at the fathers, or maybe those persons who donate sperm in this society and masquerade as fathers. Because I believe that if the men in this society took greater responsibility at what we know as parenting, what we know as fatherhood, then the situation that we see reflecting in the daily papers about those guys who are facing the law courts for the death penalty would not be there. Now, I am not saying that if you parent at a particular level that you will not still find youngsters who go rogue, as we know it. But the reality is that the block culture in Barbados will not in any way reduce itself soon. Because every day we have youngsters from in communities who are gravitating to the blocks because it is the only solace for these youngsters in life. There's no love at home, there's no father figure to actually guide them in a particular direction. And hence, the influence of peers will always redound, in some cases, to youngsters making decisions that will place them before the courts. So again, I see that as the mitigating factor to remove the mandatory death penalty from some cases that we know as murder. And I really want to send a message to the men in Barbados that if you enjoy a couple moments of ecstasy, I am saying that after that, the results, you must man up to what is happening after that. Because if we don't do that, in the constituency of St. John, in your constituency next door, Mr. Deputy Speaker, we're going to constantly see a flow of youngsters who will again and again and again end up before the court. And I spoke about sipping from the chalice of leniency. And we have examples of giants who would have walked this earth. Giants in the form of Martin Luther King, who forgive those who would have done major damage to our lineage in the United States. We have kings like giants like Nelson Mandela, who in South Africa had to face some of the most trying times and came out forgiving those persons. So I am saying the mitigating circumstances that are there is the only thing that make me support, in a sense, this particular bill as it relates to removing the mandatory death sentence. Because I understand that those issues, those socioeconomic problems that we have across Barbados must be fixed if we are to reduce the court system that we will see youngsters engaging in murder. Last month at the Vatican, Pope Francis would have made changes to the Roman Catholic teachings as it relates to the death penalty. And he would have suggested that he is pushing that the Catholic Church worldwide move away and push for the total abolition of the death penalty as we know it. So I am saying, Mr. Speaker, this particular piece of legislation has been happening from May 24th, is one that is very, very progressive, is one that is well thought out by the Barbados Labour Party. The Attorney General is doing what is required in order to make the whole country safe. The legislation that is coming is proactive legislation. It is one that will, at the end of the day, redound to a better society. And hence, I have that particular interest in supporting this bill as it currently obtained. And the reality is that the Honourable Member for Christchurch East would have identified and clearly outlined a situation where a youngster was able to turn his life around. And I believe that we should not deprive persons who are seeking redemption to have that redemption and have that redemption coming from the state. So therefore, those guys who found themselves in situations of bad company or in a situation where whatever it is went wrong, and the remorse is actually there, and we can see the fact that there is remorse, must be provided with a second chance in life to show that, yes, I would have done wrong, but now I have recovered and I am prepared to give back to society. And we must find a way to reintegrate those particular guys into mainstream society. And I have been part of the process for the better part of 20 years in terms of reintegrating those youngsters into society. And I'm aware that there is a particular program now that is targeting the blocks across Barbados to do a similar thing, to reintegrate. And the fact that we're able, as legislators, to come here and to put forward legislation that will again allow some families to have that recourse of knowing, well, my particular son, my daughter will not suffer the consequences mandatory of going to the hangman. I think that that is a plus. And I'm speaking and not leaving out the victims, because I am fully aware, I'm cognizant of the fact of the pain that is visited upon the victims as a result of murder. And hence the reason why I said, for and foremost, as a father of two daughters, I have vacillated with the issue in terms of where should I treat to the fact. But that chalice of redemption, that chalice of leniency, with a level of maturity, I think all of us on this landscape are forced to drink from that chalice as it relates to how we treat to our fellow man. And the Barbados Labour Party is leading by example as it relates to that. Now, I am aware that those persons as well who embrace pro-life are seeing abortion as being more prominent than the death penalty. And that maybe I can understand as well. But the truth is that I think that this will resolve in the minds of some persons, well, look, this is a fair government, and those persons who go before the law courts will be given an opportunity, a real opportunity, to turn around and maybe contribute in a special way to society. And the reality is that in every society, there must be measures put in place to curtail certain levels of crime. We are looking at putting measures in place to curtail this at our culture. And the sanctity of life is something that is, it is important. And those persons who take a life, I know there are lots of persons who believe in that adage of an eye for an eye. But the reality is that, again, we must look at every single case based on the circumstances surrounding that case and understand that we must protect those who, in some cases, find it difficult to think for themselves. So this particular piece of legislation, I believe, is timely. I believe that we're doing what is necessary to move this country forward as far as the legal aspect, as far as the social aspect is concerned. So I really, like I said today, want to embrace this, and I think that I would have contributed what I had to say as it pertains to this. But Mr. Speaker, before I take my seat again, I want again to place particular emphasis on the fact that the men in Barbados must man up to their responsibility of fatherhood. And it can't be a case that you're walking around in tie and driving big rides and all the rest of it, and the children that you produce are suffering. And I know from first-hand knowledge that this is happening in Barbados. And females are facing the court system in the most, embarrassing circumstances to collect money. And you have fathers out there who are not interacting with their male children. And it is forcing those youngsters to look for love on the blocks and in grouping that will only lead to a negative finale. Mr. Speaker, I'm obliged.
Thank you. Member for St. Michael South.
Thank you, Mr. Deputy Speaker, sir. I rise to support the Honourable Member for Christchurch East on his presentation this morning. And while there will be occasionally a legal after debate, rights are wrong with that penalty. Today, sir, is not that day. But I also know that we said and we promised as a government that when that day comes, we would have a much larger conversation than the 30 of us in this room. And indeed, whether or not we proceed to have a conversation on the death penalty and how we decide to move forward will depend on what the people of Barbados say they want to have through a referendum. But today, sir, I want to speak specifically to what was raised by the Honourable Member for Christchurch East, and truth be told, I found it to be very passionate and very powerful, and in some parts, very poignant. And if all that he said, and I know it is true, and considering that all that he said is true, and considering what I also happen to know, the bit I know about the law as it relates to this particular case, I believe that we, as a government, is simply doing that which we know have to do. But before I move on to speak specifically, though, to the amendments before the House, it is, as the Honourable Member for Christchurch East spoke, I reminded myself he reminded me really of a poem by Oscar Wilde, The Ballad of Reading Jail. I don't know if you've read it, Mr. Deputy Speaker, sir. But it is a most powerful piece where Oscar Wilde finds, the reality is that Oscar Wilde was in jail at the time he came up with the piece for a crime that today many men would not consider to be a crime, but he was in jail for a crime in his time. And at the time he penned the piece, it was that a man had been brought to jail for having murdered his wife. But the poem doesn't speak to whether or not it was right or wrong to commit the murder. It just spoke to the reality of being on death row and hearing the gallows being swung every morning as they made sure the gallows worked, people making jokes at you, taunting you as you were there on death row. And he said, I know not whether laws be right or whether laws be wrong. All we know who lie in jail is that the wall is strong, and that each day is like a year whose days are long. And I could just imagine for a man who finds himself on death row, that the days are very, very long. And in the circumstances that the Honourable Member for Christchurch East spoke to, I can imagine that those long days would even be longer. And so I look forward to when we have that conversation on the death penalty in further detail. I really do. Not when we discuss the removal of the mandatory provision for the death penalty. There will be a day when we have to talk in more detail about the death penalty, and I look forward to that conversation. I will tell you why. I have friends who were murdered, sir, Mr. Deputy Speaker, more than one. And I have friends who were also accused of murder. I have a very good friend who was on death row. And in fact, I saw him last week or so because he's now a freed man. And sir, I will speak when we get to that point on that issue from a personal perspective. But today, sir, is not that day. I believe, sir, that what we are here to do, in essence, is to correct a wrong in the legislation. That is how I see this. And that, essentially, for me, the mandatory death penalty takes away the freedom that we in Barbados wish to associate ourselves with. In a way, anything that denies freedom denies human development and human expression. And in a way, that is where we are, sir, as a country. I heard the Honourable Member for Christchurch South say that he would hope the Honourable Attorney General would do his work and continue to bring legislation to the House. And I think it is necessary, because the reality is that for the last 10 years or so, there have been a number of cases of all kinds that should have been brought to this House for discussion, things that should have happened in Barbados that did not happen, and I will probably speak to that in more detail later, but that we have to do the people's business when we come into this House. So, sir, the mandatory death penalty is on the decline everywhere. It is not only a case where it is happening in Barbados, and it is on decline largely, I am told, because of judicial challenges. And that since 2000, at least 18 countries have discarded the mandatory death penalty. Some concluded that it was unconstitutional and arbitrary and inhumane. So, Mr. Speaker, sir, Mr. Deputy Speaker, sir, we are doing in Barbados what other countries have already done. In fact, in 1976, the U.S. Supreme Court was one of the first courts to strike down the mandatory death penalty. So at the end of the day, we are not taking away the power of the death penalty, or for a judge to say the person is condemned to die. We are saying that it is not mandatory for the judge to condemn the person to die. And sir, so I want to make it very, very clear that this government is not taking the death penalty off the books, but that we're removing the mandatory death penalty. And it's also been the case, sir, with international tribunals. They have likewise condemned the mandatory death penalty. And sir, what the Caribbean Court of Justice did was in keeping with international applications, I believe, of the law. And it was what was considered to be one of the most significant judgments of the CCJ, when they unanimously declared the mandatory death penalty was unconstitutional in Barbados. They decided that the mandatory death penalty was unconstitutional in Barbados. The Caribbean Court of Justice, our highest court, sir. We are seeking, therefore, to execute that which has already basically been decided by the court. That is true. The Honourable Member for St. Peter is reflecting on my use of the word execute. But the court rules, sir, that not everyone convicted of murder deserves to be executed, and the court should be allowed to consider each case separately. They also went on to say, sir, that the Parliament was wrong to legislate for an automatic death penalty because under the Constitution of Barbados, the selection of punishment must be exclusively performed by the court, and that we had somehow reduced the court to a rubber stamping institution. So in essence, sir, we are doing what we have to do. But I do look forward to having a much larger conversation on the death penalty and engaging wider Barbados in that conversation. And so I began by saying that in my mind this is about human development and human expression. And today we make no judgment whatsoever on the rights or wrongs of whether the death penalty should or should not be allowed to continue in this country. I listened very closely to the Honourable Member for St. John, and I know how he feels about community work, and I share his views entirely as it relates to the struggle faced by people of lower socioeconomic status and the almost let me rephrase. I share his views before I say something that is not necessarily fit for this honorable place. But I share his views, and I know it is disproportionate in the way that persons born into certain classes may find themselves one before the court and two guilty. And that has always bothered me about the death penalty. But there will be a conversation for that at another time. And we don't make that judgment today. But I believe that Barbados must be able to choose for Barbados. And that we must empower the persons that we ask to be responsible for administering the laws of this country to be able to make the choices that they have to make. And that we are seeking to correct a wrong is simply that we are now seeking to correct a wrong. But what strikes me most of all about this whole thing is that for the last 10 years, I mean, it has affected both governments, but certainly the movement has been such in the last 10 years that other people have gone ahead and done it, that we have taken so long as a country to right some of these wrongs. For the last 10 years, there is a level of inertia, or had been, in this country that is perhaps unparalleled in the governance of the affairs of this country. And it is not only here. You would see the Attorney General, again, the member for Christchurch South said it, but you will see that the Honourable Attorney General, Mr. Deputy Speaker, sir, has been very, very busy trying to bring legislations to bring Barbados into the 21st century. And that we had a government that at best, sir, is guilty of doing absolutely nothing for the people of this country for 10 years. And at worst, which is probably a more accurate reflection of who they are, have done tremendous damage to the country and to the people of Barbados over the last 10 years. And I will tell you why I say that, Mr. Deputy Speaker, sir. Every single indicator, every index that matters in relation to a country's development, it is not only here that they haven't done what they were supposed to do to right these wrongs. If you were to look at our position on the Human Development Index, Barbados has fallen. If you look at Barbados' position in relation to the International Maritime Organization, we just did an audit, we failed 21 areas. Barbados has fallen. If you look at Transparency International, the Doing Business Index, everything that matters, Barbados has fallen. Simply because people who were supposed to do what they are supposed to do did not do it. We bring legislation here to do what was supposed to have been done a long time ago, sir. And we are correcting wrongs in this amendment that the Honourable Member for Christchurch East brought is what we have to do. We have now, I say to my people, we have to walk and talk at the same time. Engage the people at the same time we are doing the work. Because Barbadians should be aware of these issues that face the country. These issues, some of them not necessarily complex, but certainly they perplex people. And this is the removal of the mandatory death penalty, not in itself a complex issue, but a perplexing issue. And one that has caused all kinds of administrations grief. And we've come, sir, to correct that wrong. But at the end of the day, sir, we have to build the best Barbados. we have a responsibility, sir, to make Barbados the best that it can be. And that means in all things. I have said on more than one occasion that I have cared so deeply for the institutions in this country that have some responsibility for determining how people live, that I find it hard to accept that some of our institutions were so battered over the last 10 years. This particular chamber, this honourable house in which I have the privilege to be in, thanks to the people of St. Michael South, with a responsibility so important, bringing very little legislation to really positively impact on people's lives in the last 10 years. You heard how eloquently and passionately the Honourable Member for Christchurch East spoke this morning, speaking to issues that are pertinent to who we are fundamentally as a people, as we seek to address what really and truly is a wrong. You heard the member for St. John speak to our need for our community. In fact, you would hear all of us speak to it because we understand it, what it will take to move this Barbados forward and to bring it into the 21st century. And sir, maybe one day, maybe, hopefully soon, we will get to debate the death penalty. But today, sir, is not that day. And I make the point again that I don't want Barbados to walk away thinking that this Barbados Labour Party government came into this honourable place and somehow decided under the veil of night to slip the removal of the death penalty away from the arms and the authority of those who should have it, because we haven't done so. We have just removed the mandatory part of the legislation, sir. And sir, there will be a time when we will come to this honourable house, sir, and talk more deeply about governance and why it is that legislation coming out of this place should be frequent and why it should be meaningful, because these things matter to people. And, you know, I think if there is one thing that perhaps we probably need to do more as a government, and I know we've done a lot of it, certainly more than any other government, is to continue to share with the ordinary man and the ordinary woman in this country what it is that we do when we do it and what bearing it has on their lives. And I heard the Honourable Member for Christchurch East as he spoke to the young man who almost fell to pieces when he, without intention, had taken the life of another person, to have it read to him that he will be taken to a place to hang until his body was deprived of life. That's a serious thing. In the instance where you never set out to do it, in the instance probably where the judge, if he had an option, would not have read it, would lend a young man to have to take his own life. These things have real impacts on real people. And that is why we come to this honourable place on this day to correct a wrong. And sir, before I take my seat, I listen very closely to all who make contributions in this honourable house. I listen and I try to assimilate, I try to learn. I try to learn from those who were here for forever, like the Honourable Member for St. Michael North, who deserves to be here for 6 terms, and who I think the House should recognize has been, very recently, is 24 years uninterrupted in this place, along with the Honourable Leader of the Opposition. But I sit, sir, and I listen and I try to learn, because that is why we are here. We learn so that we can carry forward for the next generation. It is the same thing that we bring legislation to this House. The Honourable Deputy Speaker, sir, has been here for 30 years? 28 years?
24.
24 years as well? Well, sir, we commend you too.
This is topic.
And these things are significant achievements. And to have done so, sir, and to do justice to your country, sir, I commend you. But I will never take this position where I stand here And I allow the people of Barbados to forget what it is that the last government has done to us. We are discussing something that they should have done. I find myself in a ministry grappling with things that they should have done. You can't find the paperwork. You can't find the money either, I'm told. But you can't find nothing. No kind of benchmark, no light post, nothing to guide you as a young minister in the ministry in the last 10 years. Sargasm on the course is acting like it's the first time they've seen it. You got to start from the beginning. The honorable member for Christchurch is dealing with sewage almost from the beginning. Difficult things that should be, for us, sir, in a position to build on what was left. Nothing. We cannot let them, the good people of this country, forget. As I close, I want to tell you a story. It seems to me that they have decided now that they must share the members of the former government. And every time they see Kurt Humphrey, that they must give me some kind of advice, Mr. Deputy Speaker, sir. So I've now been advised 3 times by members of the other side, or former members. And I am a decent person. I don't shut them down. I listen and discard, Mr. Deputy Speaker, sir, because if you could do the kind of harm that you've done to this country, what are you talking to me for? What you talking to me for? Wait. So we come, sir, to do justice to the people and for the people of this country in all that we do. And every piece of legislation that we've brought here, sir, is fundamentally important. This amendment, this series of amendments that are now before this House, sir, are so significant in my mind to give the people we've authorized to make those judgments the freedom to make the choices. And fundamentally, that is what human development is, the expansion of freedom. And sir, I wish to commend the honourable member for Christchurch East and to offer my fullest support to these amendments. I am obliged, sir.
Obliged. Member for the City of Bridgetown.
I beg to move the suspension of the debate on this bill for further consideration.
The question is that further consideration of this bill be deferred. All those members in favor say aye.
Aye.
Those against say no. Methinks the ayes have it.
Mr. Deputy Speaker, with that, we've come to the conclusion of government business for today's sitting, and I beg to move the adjournment of the House until the House reconvenes on Tuesday the 18th at 10 o'clock in the forenoon.
Second. The question is that this House be now adjourned until Tuesday the 18th of September at 10 o'clock in the morning. All those members in favor say aye. Those against say no. Methinks the ayes have it. This House is now adjourned until the 18th of September at 10 o'clock in the morning.